Good evening, everyone. My name is Corbin Eddings. I am the chair of the Ethics Committee. We're here tonight for an ethics hearing. Today is Tuesday, December 14th. The time was supposed to be 6:30. It is now 6:40. I apologize for our tardiness, but I do thank you all for being here with us this evening. The first order of business, Mr. Terry Hunt, Councilman Hunt, sir, would you lead us in invocation?
Let us pray. Dear Heavenly Father, we come to you today, dear Lord, thanking you and honoring you and praising you. Dear Lord, we thank you for your love, your mercy, and your grace, and for the beautiful sunshine that you bestowed upon each and every one of us today. Dear Lord, we ask you to be with us as we go through this night. We ask you to be with those that have lost loved ones, those that are sick and afflicted this evening. Dear Lord, we just ask you to wrap your loving arms around each and every one of us. Dear Lord, and we just pray for our nation, that our nation would be healed all the way around the world, dear Lord, that with this pandemic going on, dear Lord, we just ask the people to understand what's going on around them and to make sure that we keep you in front of everything and every decision that we make. Dear Lord, and we just thank you again for all that you do, for we ask these things in your name I do pray. Amen.
Amen. Thank you, Councilman Hunt. Ms. Sharon, if you would you give us a roll call, please?
Corbin Eddings.
Here.
Ricky Burnett. Sharon Hunt. Here. Gerald Goolsby.
Here.
Harold Smith.
Here.
Ted Woodell.
Here.
Wendy Moore. Carrington Locklear.
Here.
Larry Chavis.
Here.
Richard Jones.
Here.
Reginald Oxendine. Dewey McNeil.
Here.
Marshall Locklear. Terry Hunt.
Here.
Shelley Strickland. You have a quorum.
Thank you, Ms. Sharon. We have a couple of items that we'll be addressing this evening. First, I would like to do just a small amount of housekeeping. If you would, turn all cell phones on mute, vibrate, whatever you might need to do so that we don't have any interruptions there. And if you're going to speak, please make sure that your mic is turned on, and you may need to lean into that mic some so that everyone can hear you. I assume we're okay with our live stream, Ms. Belinda? Excellent. Sounds great. Okay, the first item that we'll be discussing tonight is an ethical complaint against Council Member Marshall Locklear, which was filed by Mr. Jamie Lowry. And the way we'll be handling things this evening, Mr. Lowry will first get to address the council and address his complaint, provide any additional evidence. At that time, following that, Ms. Marshall will do the same likewise. If at any point council members have a question, please ask to be recognized. I'll recognize you, and then we'll proceed with those questions. At the end of any and all questions, we'll then deliberate, and hopefully we can come up with a solution. First up is the Jamie Lowry ethics complaint against Council Member Marshall Locklear. Welcome, Mr. Lowry. Thank you for being with us, sir. At this time, I'll turn it over to you.
Yes, sir. Thank you. First and foremost, I'd like to thank everyone for this opportunity to express my sincere thanks and gratitude for the members of this committee for allowing me to come before you in this matter. I am a veteran that faithfully served this nation, state, county, and tribe for 28 years. I came from a small segment of population that guarded the national wall of freedom that we all enjoy. From natural disasters to overseas operations, I answered the call. I can come before you this evening to get you to answer the call on behalf of this tribe. A wise man once said, anyone can talk about what should be done in any given moment, but most won't do anything about it. I would prefer to do something other than hang out on social media and talk about criticizing. I trust that you, the members of this committee, prefer to do the same. Mr. Chairman, I request the documents that I provided to you, to the chairman of this ethics committee via email, entitled LTNC_ethics committee letter 1201221_1900 be entered in the official record of this meeting. This document is 11 total pages, 8 pages consisting of a letter and 3 attachments, outlining in extensive detail the ethics violations of 2 members of this committee. This document is the official complaint filed in accordance with Section 5-1 of CLLO-0312-01, last amended on October 21 of 2021. Based on the tribe's ordinance approval process, it is my understanding that the last amended version of this ethics and conflict ordinance, referred to as an ethics ordinance, became effective on November the 20th of 2021. I have standing to file this complaint as an actively enrolled member of the Lumbee Tribe of North Carolina, and in accordance with Section 5-1 Alpha of the ethics ordinance, I will state the grounds for my belief in nature of the alleged violations. On November the 22nd of 2021, at approximately 6:30 p.m., purported members of the Tribal Ethics Committee convened a hearing to address a complaint filed by Ronnie Oxendine against the Lumbee Tribe against the Lumbee Tribe Supreme Court. During this hearing, there were 2 members of the Ethics Committee that had actual and apparent conflicts of interest as outlined in the ethics ordinance. Both individuals participated in the hearing, actively took part in deliberations of this ethics committee when it retired to discuss matters in closed session. In both instances, they violated the ethics ordinance. In accordance with the definition section of the ethics ordinance, the following terms were defined. Conflicts of interest. A member has a conflict of interest when the member exercises an official power or performs an official duty or function in the execution of his or her office, and at the same time knows that in the performance of the duty or function or in the exercise of the power there is an opportunity to further his or her private and or personal interest. Apparent conflict of interest is defined as a member has an apparent conflict of interest if there is a reasonable perception which a well-informed person could properly have that the member's ability to exercise an official power or perform an official power or duty or function is likely to have been affected by his or her private and or personal interest. The council members that violated these ordinances were Wendy Moore and Marshall Locklear. Both members have actual conflict of interest and apparent conflict of interest surrounding the Ron Oxendine complaint against the Lumbee Tribal Supreme Court. Both members exercised an official power or performed an official duty or function during the hearing, which is required in the definitions I provided. Both members have private and or personal interest in the matters related to Ron Oxendine and the allegations he made against the Lumbee Tribe Supreme Court, which is also in the outline definition. As discussed by the chairman, the first one we'll discuss is Marshall Locklear. Locklear's apparent conflict of interest lies in her relationship with an interested party in litigation between Lumbee Tribe Enterprises, LLC, and Ron Oxendine in Robeson County Superior Court. Locklear has violated the tenets of the ethics ordinance. Locklear did not, in the performance of duty, comply with Section 2 of the ethics ordinance. During Mr. Oxendine's introduction of his case on November the 22nd of 2021 of the Ethics Hearing Committee, Oxendine referenced a timeline that he was sued by Lumbee Tribe Enterprises, LLC. That case that Ron Oxendine referred to did not name him as the sole defendant. In fact, Ron Oxendine and Spencer Locklear were both sued by Lumbee Tribe Enterprises, LLC. It is widely known throughout the tribal territory that Spencer Locklear is the spouse of Marshall Locklear. The term spouse is defined in the ethics ordinance as a person who is married to an individual defined in section 1, number 1, or a person who lives with a member as a husband and wife. It is public knowledge that Lumbee Tribe Enterprises is 60% owned by Lumbee Tribe Holdings, which is 100% owned by Lumbee Tribe of North Carolina. As set forth earlier, the apparent conflict of interest is defined as a member has an apparent conflict of interest if there is a reasonable perception that a well-informed person could properly have that the member's ability to exercise official power or perform the official duty or function is likely to have been affected by his or her private and or personal interest. If the tribal members were well informed of the recent litigation involving LTE and Ms. Locklear's spouse, Spencer Locklear, it would create a reasonable perception that Marshall Locklear does in fact have a conflict of interest. This is a conflict in her private capacity as the spouse of Spencer Locklear. I will now outline the three counts of apparent conflicts of interest. On count 1, she failed to disclose the nature or conflict of interest or according to the laws of the tribal government, as required in section 2.2 alpha. Specifically, she knew that her spouse was sued by LTE, along with Ron Oxendine, and she did not disclose this conflict at the beginning of the hearing or any other time. Count 2, she failed to withdraw from any meeting or discussion if he or she becomes knowledgeable that a conflict exists. As required in section 2.2 Bravo, she knew that her spouse was sued by LTE along with Ron Oxendine, yet that she did not withdraw from any discussions. Count 3, she failed to ensure that a written record shall be made that includes the withdrawal of the person from the meeting and conflict of interest was discussed or addressed. In section 2.3 specifically, Locklear failed to disclose and withdraw as it relates to her spouse being sued by LTE, along with Ron Oxendine. She consistently did not cause the creation of a written record in the official meeting minutes, which means that there will be no written record of her connection during that hearing. The next thing I would like to do is direct the committee's attention to attachment 2. That is marked filed. Within that attachment marked attachment 2, it's marked filed from Superior Court case 2-1 Charlie Victor Sierra 1964. And it states 2 defendants' names, Ronnie Oxendine and Spencer Locklear. The next one I'd like to draw your attention to is attachment 3. Attachment 3 is also associated.
Excuse me a second. Just so we don't have any confusion, I think these may be exhibits A, B, and C is how they may be listed for you. Is that correct? Oh, okay. I'm sorry. Okay. Oh, okay. I'm sorry. I apologize. Thank you, sir.
Mr. Lowry, can you call out page numbers when you were reading? If there is a page number, are we looking at the same thing you are?
No, sir. I've abbreviated it for the sense of time.
Okay.
You have about an 8-page letter there. I'm trying to condense it down a little bit.
Gotcha.
Attachment 2 would be this one.
On page 5 of 8, where I located it. Thank you, sir.
Again, that attachment 2. Yes, ma'am. I'm sorry. Attachment 3 should have been labeled at the top, and it should read, a certificate of service is what it's entitled. Okay, attachment 2 was marked, filed, and again, it's from the Superior Court case 2-1 Charlie Victor Sierra 1964, and states both defendants' names, Ronnie Oxendine and Spencer Locklear. Attachment 3 is also associated with that same Superior Court case 21 Charlie Victor Sierra 1964, which is the certificate of service. It details the attorneys for the individuals in the case. Terry Frank Law, Smith Anderson, Blunt, Dorset, Mitchell, and Jernigan are listed as the attorneys for Lumbee Tribe Enterprises. Spencer Locklear's attorney is listed as Danny Earl Brick. Ronnie Oxendine's attorney is listed as Walter Tippett. Attachments 2 and 3 not only reflect that Locklear's spouse was named as a defendant in the litigation, but it also validates that no member of the Lumbee Tribe Supreme Court is listed as any attorneys for any parties represented in that case. The court documents also indeed are easily accessible by a well-informed tribal member through the clerk of the court and can provide great detail into that litigation. Ms. Locklear, through her actions and inactions, violated her constitutional duties as a tribal council member as set forth in counts 1 through 3. All facts supporting this complaint against Ms. Locklear are on video and in the documents in possession of the Ethics Committee and the Tribal Council. Mr. Eddings, if it pleases the committee, I've had a couple questions that we could ask to kind of clear up all these matters and make it really quick for us.
Questions were directed to
Ms. Locklear.
council members. I don't think we're going to go to that point at this time. Was that the end of the presentation?
I will yield my time.
I'm fine with it. I have.
Okay. Mr. Lowry, you can proceed, sir.
Ms. Locklear, is Spencer Locklear your spouse?
Yes, he is for 30 years.
Were you president for the committee hearing on November the 22nd of 2021, the Ethics Committee hearing related to Ron Oxendine versus Joshua Malcolm and the Lumbee Tribe Supreme Court?
Yes, I was.
During that hearing, Mr. Oxendine provided an introduction to the hearing, and he referred to a timeline that he had been sued by Lumbee Tribe Enterprises. Do you recall that timeline?
I can't tell you the timeline, but I did hear him speak.
Was your spouse involved in the litigation that Ron Oxendine referred to?
According to the paperwork you have, he was sued individually by LTE, yes.
Was your spouse involved in any litigation where your spouse, Spencer Locklear, and Ronnie Oxendine were named as defendants in legal proceedings in Robeson County Superior Court?
According to the paperwork I have seen, yes. I did not attend any trials or any hearings or any depositions.
So along with that, you would agree that your spouse was named as a defendant in Superior Court case 2-1 Charlie Victor Sierra 1964?
According to the paperwork that you submitted, yes.
Do you know if the organization that is listed as the plaintiffs in Superior Court case 21 Charlie Victor Sierra 1964 is partially owned by Lumbee Tribe Holdings, which is 100% owned by Lumbee Tribe?
If you are referring to Lumbee Tribal Enterprises, yes.
Are you familiar with the Ethics and Conflict of Interest Ordinance?
I am not, for the simple fact, if you looked at when it was voted on, I was not even present when it was voted on.
That was the next question. So during the process of amending that, you were not present?
No, I was not present.
That's all the questions I have, sir.
Thank you, Mr. Lowry. Ms. Marshall.
Thank you. So, Mr. Lowry, as I'm very unfamiliar with who you are, I do have a few questions for you because I would like to get to know my accuser a little better. I can see from the complaint that you did sign it as First Sergeant, U.S. Army retired, and you've already told us that, so thank you for your service. I can also see you reside in District 8. Who is your representative for District 8, and did you speak with him or her prior to filing this complaint for direction on how to go forward?
Mr. Corbin Eddings is my representative in District 8, and I emailed Mr. Corbin Eddings on this matter.
And did he give you direction on how to move forward?
You mean, I'm not certain what you're looking for, the direction.
So with your complaint, did he tell you how to move forward?
No, that's actually laid out in the ethics ordinance.
Okay. And now that you've retired from the U.S. Army, could you tell me where you're employed in your position?
Well, I've actually had about 2 jobs since I retired from the military. The most recent departure I did, I was actually the representative for Lumbee Tribe, where I was putting veterans back to work. The second position I now hold, I work for Lumbee Tribe Enterprises as the facility security officer.
And since LTE is 60% owned by LTH, which is 100% owned by the Lumbee Tribe, did you speak with anyone that you worked with prior to filing a complaint?
I did not.
In your complaint, you accused me of failing to disclose the nature or the conflict of interest according to the laws of tribal government. You used a suit by LTE versus Ronnie Oxendine individually and Spencer Locklear individually as your evidence. I've already gave to Belinda, and I would like to request that the documents that are filed, Exhibit A, B, and C, be submitted.
Everyone has copies of those?
No.
Miss Belinda. Can we get one more copy of Exhibits A, B, and C for Mr. Gerald?
So in Exhibit A, 21-CVS-1964, order granting defendant Ronnie Oxendine's motion to compel arbitration and to dismiss, or, in the alternative, to stay, and Exhibit B, 21-CVS-1964, order vacating temporary restraining order and denying plaintiff's request for preliminary injunction. According to Item 6 of both documents, signed by the Honorable Jason D. Disbrow, on 9/21/21, the court has previously dismissed all claims against defendant Locklear pursuant to his Rule 12b-6 motion for failure to state a legally cognizable claim against him. With that being said, I see no reason to disclose any information as you listed in Count 1, nor did I see a reason to withdraw from any meeting or discussion as listed in Count 2, and therefore making no written record as listed in Count 3, as I did not perceive there to be an ethical dilemma or a conflict of interest, since the charges that were brought forth from LTE on my husband were dismissed. Furthermore, this lawsuit was made public, and Councilman Gerald Goolsby made sure the entire council was aware, as he sent this to all of us in a text. Therefore, if any of my fellow council members thought there was a conflict, why did anyone not speak up on the night of the ethics hearing? The Supreme Court case, David Locklear versus Ron Oxendine and Tribal Election Board, was filed on October 6, 2021. During this case, Joshua Malcolm served as Supreme Court Justice when in fact he himself had been involved in 2 prior lawsuits against Mr. Ron Oxendine. And although you have carefully shown that he was not listed in these complaints, he was involved. One of the cases, as I previously mentioned, is what we're talking about. According to Malcolm, the North Carolina State Bar has allegedly written a letter stating that it was not a conflict of interest for him to preside and rule in the court case, David Locklear versus Ron Oxendine and the Tribal Elections Board. Joshua Malcolm, who represents LTE in a capacity, previously lost both cases against Mr. Oxendine in a North Carolina court system. This can clearly be seen in Exhibit A, where the judge has ruled in Oxendine's favor.
Excuse me a second. I just want to make sure that I make a couple of things clear before we go a whole lot further. I don't want us to end up going down the wrong road. First, I probably should have said this a few minutes ago when it was actually asked where Mr. Lowry was a resident of, or who was his representative, or what have you. So I want to make one thing abundantly clear. I knew nothing about any complaint until a complaint got emailed to me. No involvement in any way whatsoever. However, I will say this. If a tribal member contacts me, and I hope if a tribal member contacts any of you and asks, how do I file an ethics complaint, that you would tell them. That's our job. If they believe there's a violation. Now, there may or may not be, but I want to make sure we understand I didn't do that, but I wouldn't see a problem if I had, because I think that's what we're supposed to do. Secondly, let's make sure that what we're discussing tonight are counts that were brought related to ethical violations of council members and whether we feel they violated an ordinance we wrote, whether we do or don't. This is not the ethics hearing that's scheduled for Thursday. I don't want it to become the ethics hearing that's scheduled for Thursday. Let's stay focused on the task. Let's stay calm. Let's stay professional. Let's move forward and address what we're looking at in black and white. Thank you.
Unfortunately, Corbin, the ethics committee that we will address Thursday, this is part of it, unfortunately. If there was no conflict with Joshua Malcolm acting as Chief Justice in which he presided and ruled on a case that involved Oxendine, a person previously sued by Lumbee Tribal Enterprises while he was acting as Lumbee Tribal Enterprises counsel, then there should be no conflict in me participating in an ethics committee meeting when the lawsuit against my spouse had been dismissed prior to any of this going on as a failure of LTE to have a cognizable claim. Joshua Malcolm set a precedent when he presided and ruled in that Supreme case. In tribal law, we don't use precedent, but we use Lumbee custom. Mr. Lowry, are you trying to tell me that there are double standards in our court system where Mr. Malcolm has gone after a person but can sit and preside and rule, but yet you're telling me that I can't put away my feelings, my thoughts, my processes, and rule in an ethical manner? You're conveying that my actions are unethical when in fact the Supreme Court has done the very same thing and it was perceived as ethical. Furthermore, if you would take a look at Exhibit B, page number 7, item number 3, which states in the court's reasoned discretion, defendants Oxendine's motion to strike the affidavit of Jamie Lynn Lowry is granted. Therefore, Mr. Lowry, you were also part of this same lawsuit, LTE versus Ronnie Oxendine individually and Spencer Locklear individually. It is in my opinion that since you did not successfully fulfill your agenda, that is why we are now here wasting the membership's money and time. Do you not find this an ethical violation or a conflict? Especially since you did not disclose this information in your complaint and only shared partial documents of your evidence against me. And since you've submitted and used the lawsuit, LTE versus Ronnie Oxendine individually and Spencer Locklear individually, I will continue to reference the outcome of this lawsuit. Exhibit C, 21-CVS-1964. Ordering, granting motion to seal, vacate order to seal. Item number 9, per the Honorable Jason D. Disbrow. The U.S. government has not filed any pleading or made any kind of appearance in this action which would lend credence to any argument regarding a compelling government interest. In fact, the only interest that LTE seems to be concerned with is its own interest in keeping these proceedings confidential and the interest of current employees of LTE wanting to maintain their positions of authority. So, Mr. Lowry, is that why we're here, to continue to protect your own interests and those of LTE? And also in the original filing, you emailed Corbin Eddings, chairperson, Ricky Burnett, vice chair, Sharon Hunt, secretary. But you also copied Gerald Goolsby and Terry Hunt. So help me understand why you only chose to select those few committee members out of the 15 committee members to send emails to. I understand the first 3, but tell me why Terry Hunt and Gerald Goolsby.
First of all,
because I can answer for you.
Mr. Chair, I have a point of order, please.
Hold on one second.
Let me finish. I'll let him finish. Now it's my turn to finish.
Let's make sure that we don't ask questions and then not expect a response.
I'm almost there. He can answer when I'm finished.
I don't recognize what the question is at all at this point. You've rambled
Well,
for
my
15
question
minutes.
is this. You alleged that I had participation in the meeting. Since nothing was said out here in the chambers and everything was said in closed session, how do you know that I actively participated in closed session?
So the question is, did I not know that you walked out of the door and went into?
How do you know that I actively participated in closed session?
I'm not.
I went out that door. Do you not know if I went to the bathroom? Did I go to the mailbox and check it? How do you know that I actively
Mr. Chair,
participated?
are we still having a
You are
professional meeting
accusing
here or
me,
what?
so I would like an answer.
Okay, now, into that question. Response.
I don't know what the question was at this point.
How did you know that I participated in closed session?
I do not know that you.
But you alleged in this
Hold on, Ms. Marshall. Hold on, Ms.
that I
Marshall.
did.
Hold on, Ms. Marshall. You may respond. Mr. Lowry.
First and foremost, I'm not on the ethics committee. I am not an elected official. I am a constituent of everyone on this tribal council and committee and of yours. My goal is to hold you guys accountable for what you passed. For what you passed. What you say and do outside of those doors, I do not know. I can assume that you participated because you did not make anything known on that video that was publicized. There's nothing there. There's nothing in the closed session meetings, nothing other than the video, and you walk out of the door. One can only assume that you did because you did not make any kind of record to the contrary.
Assume. We all know what we say about assumptions. So are you
Mr.
telling me
Chair.
that Terry Hunt and Gerald Goolsby did not tell you that I participated in some way in this meeting?
They did not.
So why were they the only two, besides the chairman, the vice chair, and the secretary, that were emailed a copy of this complaint?
Because those are the only two members that I could find their email addresses on.
It's on the tribal website. Every email is on the tribal website.
Mr. Chair.
In my closing, I maintain that I did not commit any ethical violation. The aforementioned lawsuit against my spouse was dismissed on 9/21 prior to the ethics hearing in question. I also do not feel that the lawsuit mentioned would sway my way of thinking or allow me to make unethical decisions, as that is simply not my nature. In fact, I was not aware of all allegations against my spouse until I read the exhibits that you provided to prepare for this hearing. I don't think one person on this council can at any time name when I've made an unethical decision or cast an unethical vote. I pride myself in being honest and of good character. I'm a health care provider in this county. My profession demands that I'm honest and ethical in all my actions at all times. I've sat on this council for 3 years, and the decisions I have made, I've made to the best of my abilities and to the best for my membership. I have no underlying agenda except to do what is best for the members of the Lumbee tribe. However, based on the documents I've read and what I see, it appears that Mr. Jamie Lowry and LTE have their own interest in mind.
Sounds like we're finished there. Do we want to do a rebuttal, or do we want to go with questions at this time, folks? Any questions from the council? Let's go there. Mr. Gould.
I guess since my name was brought up a couple times in the testimony. Number one, just want to clarify, when the text message went out to all council members, it was in response to several council members asking me about a video that was on Facebook. And then when the response that I got when I talked to Josh as the chairman of the Economic Development Committee was that they was filing a lawsuit. So I informed council of what was going on. I apologize if it hit you wrong or anything like that. I didn't go to Facebook and blab it all over like others have done in the past. So that was the motivation behind that. As far as communicating with Mr. Jamie, I have not. Anything that happened in closed session, I have not told anybody about. I was asked, was I told to shut up in the meeting? And I did answer yes, and that was as far as that goes. So as far as that goes, Ms. Marshall, I'm hindsight always being 20/20, maybe I should have just texted council members that was asking the questions. But I thought all council members should know what was going on with the video and LTE as economic chair. Secondly, just comments on this whole thing. I don't think the complaint, the way I read it, and someone can clarify it to me if I'm reading it wrong. It ain't the fact that a lawsuit was dismissed, turned down, or found irrelevant. It was the fact that there was one filed. And I think that's the way I read it, that there was a lawsuit filed, and that with LTE as it relates to Mr. Oxendine. And then I think that's where the violation assumably is coming from. Secondly, as far as an email, I mean, I did get an email, and I did get email of the complaint. I did read it. I didn't see who all was in. I thought it went out to everybody, to be honest with you, but I didn't click at the top and see who all done it or nothing like that. I had no involvement in this. I don't know anything about it until I got the email that night, and so don't know where that's coming from. As far as recusal, I don't think it's my job to tell, or any council member's job to tell another council member to recuse themselves. I think that council member should know enough about it and have enough of whatever to recuse themselves. It's not my job to recuse a person. So to sit at a meeting and say, hey, Alvin, you need to recuse yourself because of whatever, I think is wrong. It's not. I think it's up to the council member to recuse. I think we just got a letter from one of our council members that was on this committee resigning because she didn't think she could evaluate it fairly. So that's up to the council members. So as far as this goes, I think the lawsuit is this complaint, and clarify me if I'm wrong, the complaint is the fact that the husband was involved in the lawsuit, not the outcome of the lawsuit. Am I correct in understanding it? And I'm not saying good, bad, or indifferent. I just want to understand.
Not necessarily, even to my understanding, and if I'm wrong, it's not really so much about the lawsuit as it is a failure to disclose that information. That there may have been some who were not aware of the lawsuit or whatever it might have been, but failure to disclose it, participating in deliberations after not disclosing it.
And that's my understanding. It's not the outcome of it. It's just the fact that it happened.
Mr. Chair.
Mr. Terry.
Yeah, also, since my name was mentioned too, I think the last time I've talked to Mr. Jamie was probably at Fort Bragg, probably about 5 or 6 years ago, right before he deployed. I think that's the last time that I've ever talked to Mr. Jamie. But other than that, I'm like Mr. Gerald. What happens in closed sessions, as far as I'm concerned, that's where it stays amongst the tribal council members that is in there talking. So why he sent it to me, I don't know. I'm like Gerald. A lot of times I have to sit there and play with the emails to find out where it's coming from and who it's going to. But yeah, when I looked at it and seen it, I read it. But then when everybody else got it, that's when I was confused of why it was like that. But to clear it up, that's the last time that I think that I have talked to Mr. Jamie I'm wanting to say 5 years ago, right before he was deployed, if I'm not mistaken.
Mr. Chairman.
Thank you. Hold on one second. Any other questions from any other council members? Mr. Richard.
I would like to say that night about council trying to recuse himself. We didn't have a parliamentarian that night, nor did we have the chair, I believe, that night. No knock on either one of those two people. I'm just stating for a fact. So when we have meetings like that and we don't, maybe we might have made a mistake. Maybe we should say, having this, we might need to designate somebody as a parliamentarian. But when it comes down, is it my understanding, I like for this, is it true that the cases were dismissed all before the elections hearings? Is that my understanding? Okay. That's correct, sir? I want to get everybody, is that what everybody's saying?
Yes, sir. Yeah, I think somebody said September
21st.
21st. Any other questions from any council member?
Mr. Chair, if I may.
Well, I'm going to let her go. She had her hand up first. We'll go here, and then we'll go here for any closing comments.
And I think this is for Mr. Gerald. This has nothing to do with the lawsuit, with the frivolous charges. What I'm trying to say is that lawsuit has no bearings on the decisions I make. None whatsoever. You're trying to tell me that the Supreme Court can make decisions when there's conflicts of interest or perceived conflicts of interest. You're trying to tell me that that court system can do more than I can do. You're telling me that this person can separate themselves and make a ethical decision, but you're telling me I cannot do the same thing. Because the way I see it, oh well, it's a lawsuit, it's gone. Did not appear to me that night that there was even a conflict of interest, because I'm just going to be honest. I hadn't looked at the agenda to see what was even going to be discussed. I don't have time. I work every day. And when we get these emails sometimes, it's right before or prior to. So when I sat in here that night, I didn't think about a conflict of interest. When I'm sitting back there, I'm just going to be honest. When they were talking, I'm like, it ain't going to go nowhere. It's a waste of time. Again, I didn't see a conflict of interest. That's why I bring up that. If he had been charged and things, then that might have been a different story for me. It was dismissed. That's why. It's not that I'm trying to tell everybody it was dismissed. What I'm trying to say is it has no bearings on any decisions I make.
Thank you. Mr. James.
Well, a couple points there, Mr. Chairman, if I would. First and foremost, if you would like to read the entire charge, you have that copy free of charge by the county. Second, my claim is not, I say again, not anything related to Ron Oxendine's claim against the tribal Supreme Court. That hearing is on Thursday. Has nothing to do with anything here. I am not a committee member. I am not an elected official. I am a private citizen who expects the committee members and tribal council representatives to uphold the standards that you all voted for. Two parts. The first one, again, the apparent conflict of interest. A member has an apparent conflict of interest if there is a reasonable perception. A reasonable perception which a well-informed person could affect the member's ability to exercise an official power or perform an official duty or function is likely to have been affected by his or her private and or personal interest. As Ms. Locklear is very heated, I believe it has affected her moral judgment. She's taken some of this personal. It is not personal. The last part in all of this is you talk about your ethics complaints. The ethics complaint related to Ron Oxendine and the Lumbee Tribe Supreme Court. I've watched that entire case. I've watched every hearing. All council members should know that this is what constituents do that want to be informed. They watch everything that's going on in this council chamber. As far as I'm aware, during that tribal Supreme Court hearing, those justices disclosed everything up front. I would expect the same from the council members that had some type of apparent conflict of interest to do the same. That's what I'm asking. Those individuals, if we're going to hold one section accountable, the other section should be accountable. Section 1.1 outlines who can be held accountable. Tribal council chairperson, tribal council members, tribal judiciary officers, including the administrative and Supreme Courts. Ron Oxendine's already filed his case. Shouldn't I get to do the same? That's all I have for this matter, sir.
Thank you. Any additional questions from council? Do I hear a motion?
I'll make a motion. We'll go in closed session.
Second.
A motion, a second. All in favor, please stand. If you would, those who are not a part of the Ethics Committee, as chairman, I'd like to invite you to take part in this closed session because ultimately whatever may or may not occur will go before the council. If you would, please join us in the back. Got a motion and a second, come out of closed session. Is there anybody opposed? All right, thank you. Thank you, folks, for your patience in bearing with us tonight. Thank you again for being here. I think, I could be wrong, but I believe the Tar Heels are playing right now. So all you Tar Heel fans, God bless you. Thank you for hanging in there through this. Appreciate everybody's time. Any comments, any motion, discussion from this council at this time? Mr. Goolsby.
Yeah, Mr. Chairman, at this time, I'm going to pretty much abstain from the vote on the motion that may be coming up because my name was brought up so much and I don't want it to be conflicted as yay or nay on anything.
Thank you, Mr. Goolsby. Anybody else?
Mr. Chairman, I make a motion. Can I make a motion?
Yes, sir, Mr. Richard.
This ethics committee thanks Dr. Locklear for her service to this committee and this council. We understand the concerns brought forward by Mr. Lowry. However, after ordinance review and testimony, we do not believe the failure to disclose a possible conflict warrants a reprimand or removal at this time.
Mr. Chairman,
And that's in the form of a motion, Mr.
That's
Richard.
in form of a motion.
I second.
Okay, we have a motion and a second. You've heard Mr. Richards' comments that he does believe he supports the concern. You folks heard it. I don't remember the exact wording, but does not believe that a reprimand is warranted at this time. Is there any discussion on Mr. Richards' motion and the second by Mr. Woodell? Roll call, Ms. Sharon. Yes.
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
Yes.
Thank you. Thank you, Mr. Lowry, if you would stay with us. Thank you, Ms. Locklear. At this time, folks, we are going to take maybe a brief 5-minute recess before we begin our second hearing this evening. Thank you. being with us this evening. At this time, we'll address the second ethics complaint that was on our agenda for tonight. And again, I'll repeat, make sure you keep your phones on silent or vibrate. When you speak, please speak clearly into the microphone. Wait to be addressed prior to speaking. And if you would, let's do our best to stay on topic as it relates to the items that are addressed in this complaint and in this complaint only. First up, we will allow Mr. Lowry, if he'd like to address this. I'm sorry. Do we need to do another roll call? As we're in a second hearing, I think I would prefer to let's go ahead and do that. So Ms. Sharon, if you would, could you give us a roll call for the second ethics hearing, please?
Corbin Eddings.
Here.
Ricky Burnett. Sharon Hunt here. Gerald Goolsby.
Here.
Harold Smith.
Here.
Ted Woodell.
Here.
Carrington Locklear.
Here. Hey, Mr. Speaker,
Yes, Mr. Here.
I want
Yes, sir. Thank you.
conflict of interest.
Thank you, Mr. Here.
Is he gonna stay for the meeting? Larry Chavis.
Here.
Richard Jones.
Here.
Reginald Oxendine. Dewey McNeil.
Here.
Terry Hunt.
Here.
Shelley Strickland. You have a quorum.
Excellent, thank you. As we do have a quorum this evening, we'll go ahead and get started. Ethics complaint this evening, Timmy Lowry, ethics complaint against council member Wendy Moore. Mr. Lowry, I'll turn it over to you, sir.
Thank you, sir. I'll just go ahead and continue on without rehashing the initial comments I made. I believe everyone was in the room for those. I will continue. Ms. Moore's actual conflict of interest lies in that she is the second cousin of a Supreme Court justice, and that she provided
Mr. Chairman,
I'm
he's
sorry, Mr.
departed
Clark,
from the
if you-
script. The complaint doesn't say second cousin, it says second degree relative.
If you would, Mr. Clark, I'm gonna let him do his opening comments, any discussion, and then we'll address that at a later time. Yes, sir, Mr. Lowry.
I say again, Moore's actual conflict of interest lies in that she is the second cousin of a Supreme Court justice, and that she provided sworn testimony in her private capacity in the case of Locklear versus Oxendine, case number 2021-001, and that she used her position as a council person in a manner to compel or coerce others to engage in political activity. During the November 22nd, 2021 Ethics Committee hearing, Moore violated numerous requirements of the Ethics Ordinance. Those include, she did not, in the performance of duty, comply with Section 2. I've outlined 9 counts of Moore's actual conflict of interest. Count number 1, she failed to disclose the nature or conflict of interest according to the laws of the Lumbee Tribe government as required in Section 2.2 Alpha. Specifically, she knows that she is the second cousin of Justice Moore, and she did not disclose this conflict at the beginning of the hearing nor at any other time. Next, she failed to withdraw from any meeting or discussion if he or she becomes knowledgeable that a conflict exists as required in Section 2.2 Bravo. Specifically, she knew that she's the second cousin of Justice Moore and did not withdraw. Number 3, she failed to ensure a written record shall be made that includes the withdrawal of person from the meeting and a conflict of interest was discussed or addressed as required in Section 2.3. Specifically because Moore failed to disclose and withdraw as it relates to her family relationship to Justice Moore, she consequently did not cause a creation in the written record in the official meeting documents or discussions, which means there is no written record in the meeting minutes. Number 4, She failed to disclose the nature or conflict of interest according to the laws of the Lumbee Tribe government as required in Section 2.2 Alpha. Specifically, she knew she had provided sworn testimony on behalf of Ron Oxendine in the matter of Locklear versus Oxendine, case number 2021-01. Her sworn testimony was provided in furtherance of Oxendine's claim that he was eligible to run for tribal chairman and that his name should remain on the November the 9th ballot. Oxendine's ethics filing against the Lumbee Tribe Supreme Court is directly related to the very same issue because Oxendine requested the Ethics Committee order a new election before Christmas. Number 5, she failed to withdraw from any meeting or discussion if he or she becomes knowledgeable that a conflict exists, as required in Section 2.2 Bravo. Specifically, she knew she had provided sworn testimony as described in Count 4, but she did not withdraw from any of the discussions in the hearing, as required. In Section 2.3, because Moore failed to disclose and withdraw it relates to her sworn testimony as described previously in Count 4, she consequently did not cause a creation of the written record in the official meeting discussions, which means no written record in the meeting minutes. Number 7, she failed to disclose the nature or conflict of interest according to the laws of the tribal government as required in Section 1.1 Echo. Specifically, she knew she had provided sworn testimony on behalf of Ron Oxendine in the matter of Locklear versus Oxendine. Her sworn testimony was provided in furtherance of the claims that Oxendine was eligible to run for tribal chairman and that his name should remain on the ballot for the November the 9th election. Before and during the hearing, Oxendine submitted a copy of Moore's affidavit to the Ethics Committee. At that very moment, Moore should have recognized that her sworn fact witness that she was a sworn fact witness in the Locklear versus Oxendine, case number 2021-001, and as a sitting member of the Ethics Committee, that she in fact had directly and used her authority as a council person to coerce other members of the Ethics Committee to support Oxendine's contention that was brought before the Ethics Committee. This was an attempt by Ms. Moore to coerce her fellow council members to engage in political activity, as it is defined in the ethics definitions. It is defined as an effort to support or oppose the election or appointment or a person for political office in an election or appointment. Moore's inaction when her written sworn testimony was provided to the Ethics Committee was in fact an effort to support Ron Oxendine's political office because Oxendine requested in the Ethics Committee to order a new election before Christmas with his name on the ballot. Number 8, she failed to withdraw from any meeting or discussion if he or she becomes knowledgeable that a conflict exists, as required in Section 2.2 Bravo. Specifically, she knew that she had provided sworn testimony and that testimony had been provided to the Ethics Committee as described previously, but she did not withdraw from the hearing. Count number 9, she failed to ensure that a written record shall be made that includes the withdrawal of person from the meeting and a conflict of interest was discussed or addressed, as required in Section 2.3, specifically because Moore failed to disclose and withdraw as it relates to her sworn testimony being provided to the Ethics Committee and as described in Count 7. She consequently did not cause the creation of a written record in the official meeting discussions, which means, again, there is no record. Not only did Moore not conduct herself with the highest degree of ethics or in accordance with the tribal constitution and recent changes in the ethics ordinance for which she herself voted on just 31 days prior, as she sat by and watched Mr. Oxendine's representative, Mr. Clark, referred to as the members of the Tribal Supreme Court as bums and other derogatory terms. Councilperson Moore performed her duties as a member of the Ethics Committee on November the 22nd, 2021, as she heard the complaint that Mr. Oxendine and Mr. Clark levied against the Lumbee Tribe Supreme Court. Even with her multiple ethics violations ongoing during the hearing itself, she, on multiple occasions during the hearing, tried to insert herself to ask for additional time for a late committee member, as well as demanding additional time for Mr. Oxendine's representative to outline the complaint against the Lumbee Tribe Supreme Court. Moore's next conflict of interest also took place during the November 22nd, 2021 Ethics Committee hearing. During the introduction provided by Ron Oxendine at the hearing, Ron Oxendine referred to affidavits that he was able to provide stating his place of residence. Within those affidavits, and they were marked as Respondent's Evidence Exhibit 12 in the Locklear versus Oxendine case, 2021-01. In mine, it is Attachment 1. Attachment 1 should look like this one. On the top right-hand corner, it does have Exhibit 12. This is an affidavit signed by Wendy Moore. The notarized document was signed on 13 October of 2021 by Wendy Moore and states that she had personal knowledge that Ronnie Oxendine, and I quote, Ronnie Oxendine, a candidate for Lumbee Tribe Chairman, has maintained his principal residence at 1837 Hezekiah Road in Maxton. Section 1, Paragraph 1, Subparagraph E of the Ethics Ordinance states that shall not use authority of his or her office or position directly or indirectly in a manner intended to coerce any person to engage in political activity. She further states that she had met with Ronnie Oxendine on October the 20th at 1837 Hezekiah Road in Maxton in order to get support for Teresa Locklear for tribal chair. The submission of this sworn statement to the Ethics Committee and Moore's failure to take immediate action in accordance with the Ethics Ordinance, which she just took part in 31 days before and voted on, and rewriting and voting on, provides the evidence that Moore was directly engaged in political activity while a sitting member of the Ethics Committee on the evening of November the 22nd, 2021. Ms. Moore, through her actions and inactions, violated her constitutional duties as a tribal council member, as set forth in counts 1 through 9. All facts supporting this complaint against Ms. Moore are on video and are in documents in possession of the Ethics Committee and the Tribal Council. The last portion I have here is the sanction sought as outlined in the ordinance. The sanction sought outlines that upon knowledge of the conflict of interest by any written or oral communication, that members should disclose the nature of conflict of interest according to the laws of the tribal government. Ms. Moore did not disclose the conflict or apparent conflicts of interest. She has violated her oath of office by not disclosing the conflict of interest and continue to hear statements made by Mr. Oxendine and his representative. As a result of the failures to properly disclose these conflicts, Ms. Moore should be immediately removed from the Ethics Committee and prohibited from holding any leadership position or role, such as chair and any other committee for the duration of her tenure in the Lumbee Tribal Council. She should also be reprimanded by the Speaker and an official reprimand entered into the record. Finally, she should apologize in public during the next full tribal council meeting for using her position to benefit what appears to be either flagrant or outright disregard of the Lumbee Tribal Constitution and applicable ordinance for personal agenda. I will yield back my time, sir.
Thank you, Mr. Lowry. We'll hold questions until the end. At this time, I'll turn it over to Ms. Moore, her representative.
Thank you, Mr. Chairman. At this time, Mr. Clark will begin with his narrative.
Mr. Clark.
Thank you, Mr. Chairman. Could I ask, does all the members of the committee have the ethics ordinance with them?
It's actually included in our packet this evening.
Okay, because I want to draw attention to that. I'd like you to read along with me, if you will. Before I begin, I would like to ask Mr. Lowry 2 or 3 questions in order to create a written record so I can be certain as to where we're at.
You want to do that now or at the end?
No, sir, I will wait till the end.
We'll catch those at the end, Mr. Clark. If you would, this time just address any information you have or evidence that you have.
Well, I would also like for the committee to take note of the fact that Mr. Lowry first filed this complaint on the 28th, I believe. And then this past Friday, I've lost track of the date, perhaps that was the 10th, right? He filed an amended complaint, and we're having this hearing today, which is 2.5 business days later. When the tribal ordinance that this committee operates in says that the accused will be presented the complaint within 5 days of the complaint being registered, and then the meeting being scheduled, or convened rather, within the next 15 business days. I know that Ms. Moore has already objected to you and that he was allowed to amend his complaint Friday. Well, that was bad enough, but now he filed it, then he amended it, and now he reads in his narrative, and now he's amending it again. Because the narrative does not support, Moore's actual conflict of interest lies in that she is a second-degree relative of a Supreme Court justice. That was his complaint. That's the basis by which you heard this. And so he has amended it now to say second cousin.
1 second. Yes?
Just one. Feel like you need to postpone this thing so you can have your 5 days that he just referred to? If so, we need to go ahead and do that without hearing everything.
No, Mr. Goolsby. I think the Lumbee people have had their fill of all of this, so I would move that we go ahead and finish this as expeditiously as possible.
Thank you.
Thank you. I'd like to direct your attention, if you will, to that first page of Mr. Lowry's complaint. To the middle of that, it would be the 4th paragraph, but the bigger paragraph. It begins on November 22nd, 2021. I'd like for you to, in the middle of that paragraph, beginning with the sentence that says, both individuals participated. Do you see that? I'd like for us to read beginning there. It says, both individuals participated in this hearing and actively took part in deliberations of the Ethics Committee when it retired to discuss matters in closed sessions. Mr. Lowry has referenced the discussions that took place in closed session not 1 time, but 5 times. So the basis of his complaint is that he is privy to what took place in closed session. The question that I intended to ask Mr. Lowry, and I'm not asking you, but I want to give him time to prepare it. My first question to him would be, was he in there? Did he participate in the closed session? And if his answer is no, I did not participate in there, then my next question to him would be, who of the at least 11 Ethics Council members that were in closed session told Mr. Lowry about what was discussed or what was not discussed in closed session? If his answer is no, then he began his complaint with a lie. If he wasn't there and you didn't tell him, no less than 5 times he spoke it to this committee as though it were fact. To create a written record, my next request, Mr. Chairman, would be from you. And I would request that the secretary of this committee do a roll call of all the members who were present on the 22nd and ask each individual ethics committee member for the record if they spoke to Mr. Lowry concerning what was discussed in closed session. I will make that request of you at this moment, sir.
And I'll note that, Mr. Clark, and we will address that before we close this evening.
Because someone is unethical. Mr. Lowry is unethical, and the fact that he blatantly and purposely lied, or someone on this ethics committee has violated their presumptive oath of silence and secrecy as to what took place back there. But the 65,000 people in the Lumbee tribe on the membership roll, we need to know who the enemy is. And we will get that by creating a written record of who says what. You just cannot make frivolous accusations without evidence to support it. He has offered none. Now I'll continue with the narrative, sir. The foundation, the basis of Mr. Lowry's complaint, in his own words, is found in the beginning of the first paragraph on page 2. The first paragraph on page 2, and I quote, Moore's actual conflict of interest lies in the fact that she is a second-degree relative to a Supreme Court justice. And he's speaking of Justice Eric Moore. And it is, in fact, false. That's lie number 1 of many written in this complaint. Wendy Moore is not a second-degree relative of Justice Moore. Let me repeat. Wendy Moore is not a second-degree relative of Justice Moore. And if she were, it would not be a violation of the Ethics and Conflict of Interest Ordinance. At this time, I would invite your attention to the Ethics and Conflict of Ordinance. I would like to direct you to Section 2 and paragraph number 6 of the Ethics and Conflict of Interest Ordinance. Section 2 and paragraph 6 of the Ethics and Conflict of Interest Ordinance. I'll give you a minute just to get there. Does somebody need more time? Section 2, paragraph 6 of the ordinance reads, a judicial court judge shall not be qualified to act as such in any case where he or she has direct interest or where any party involved in the case is a relative by marriage, in blood, or in the first and second degree. A judicial court judge cannot participate in a court case. So by saying now that Wendy Moore is a relative of the first or second degree is lie number 2. The term, look at your ordinance, the term first or second degree is used exclusively of court justices themselves. We just amended that ordinance. We ought to be very familiar with it. The term first or second degree is used exclusively in reference to court justice themselves. This term does not apply to ethics committee members or tribal council members in the exercise of their committee or council duties. That's the basis of Mr. Lowry's actual conflict of interest complaint in his own words. The complainant, Jamie Lowry, goes on to say, and I quote, I'm going to read that again, Moore's actual conflict of interest lies in that she is the second cousin. The first complaint, he said, aunt. Now he amended it to say second cousin. Lies in the fact that she is the second cousin of Justice Everett Moore. At this point, Mr. Lowry has described Moore, one, as being a second-degree relative in his complaints, has described Miss Moore as being an aunt to Justice Everett Moore, when in fact she is neither of the two. The familial relationship by which Jamie Lowry filed this complaint does not exist in your ethics ordinance that you just amended the other day. Let me read again Mr. Lowry's words from the top of paragraph 1 of his written complaint. Moore's actual conflict lies in the fact that she is a second-degree relative to a Supreme Court justice. Moore's actual means existing as fact of experience. Mr. Lowry says, I know that. It is fact. Right? It means be real as opposed to potential, not perceived, not I think it is, but he is definitively stating as a fact that she actually is related to him in these ways. Mr. Lowry's entire complaint is based on these two lies. The entirety of the 9-count ethics complaint by Mr. Lowry hangs on the hinges of these lies. Without these lies, we wouldn't be here tonight defending Wendy Moore from these false charges, and you wouldn't have to be enduring me again. Mr. Chairman and members of the Ethics Committee, I invite your attention to the second paragraph, 1A. This is in the ordinance. And this is what it reads. Upon knowledge of the conflict of interest by any written or oral communication.
I'm sorry, Mr. Clark.
I'm looking on, and I apologize to you that I'm about as lost as a bat right now.
I think you're at section 2A.
Yeah, yes, sir. And I apologize for that.
That's fine.
I threw this together this afternoon and hadn't had time to really to do it like I'd like to do it. But it says, upon knowledge of the, you're there, right?
Yes, sir.
Upon knowledge of the conflict of interest by any written or oral communication, Mr. Lowry submitted this complaint written, correct?
Yes, sir.
Has to be written, right? He must then disclose the nature of the conflict of interest according to the laws of the tribal government and or any funding agency involved. That's in the ordinance, correct?
Well, actually, Mr. Clark, just for clarification, that section 2A is as it relates to council members, what council members must do. If you're discussing Mr. Lowry's requirements as they relate to the ordinance, that's in section 5, number 1. Section 5, 1A. Is that where you were going to?
No.
Because you did say 1A initially.
I apologize to you. I may have cited the wrong thing.
Oh, no, you're fine, sir.
Just give me just a minute. Mr. Chairman?
Yes, sir.
The complainant's responsibility in filing the complaint begins in section 2. A person identified, this is number 1, in section 1 of this ordinance, which y'all are, shall not exercise an official power or perform an official duty or function if the person has a conflict of interest or an apparent conflict of interest. Right? Then, am I still in the wrong place?
I think if you go to section 5.1a, you'll be right on track.
Did I write the right one?
Yeah, section 5.1a.
I'm old, man.
That's all right.
I'm about 79. I have a lot of Joe Biden moments. Excuse me, just give me a moment, sir.
Oh, you're fine, you're fine.
Okay. I'm going to, Mr. Chairman, I believe that you're right and I'm wrong. So I'm going to omit that.
I don't hear that at home very often. I appreciate it. All right, let's roll. I'm in a good mood now.
You may have more in common than we think.
Amen.
Okay. But let's continue.
Yes, sir.
Let's continue. In the absence of that, he is still yet to identify a violation of a tribal ordinance. He hasn't cited one yet. And we'll go down now at his counts, okay? And I'm not going to be long, I promise you.
You promise?
I promise, I absolutely promise.
All right.
I got y'all kind of upset with me the last time. I'm going to try to leave here a little better shape than I did the last time. You know? And I had the britches beat off of me because I was long-winded. So I'm going to try to be a little nicer. And I haven't joined the Toastmasters yet to win friends and influence people, but I may sign up. Yes. At some point, I was waiting to be accused of it by certain people up here. Look at count number 3 of Mr. Lowry's complaint. She, he's meaning Wendy Lowry, Wendy Moore. I've had Lowry on my mind so much that I'm afraid I'm going to dream about him. Count number 3 of Mr. Lowry's complaint. She, meaning Wendy Moore, failed to ensure that a written record shall be made. The tribal council, the tribal ordinance, and I'm not going to bother you with what it is, that established the rules for tribal council and committee guidelines and decorum. And section 3, paragraph 1 says that minutes, the creation of written records of meetings shall be recorded by the committee secretary. Sharon Hunt is the secretary of the ethics committee. It's her duty to ensure that written records are made, not Wendy Moore, nor ever how many there are of you up here. Wendy Moore is not bound by any provision of any rule of law of the Lumbee tribe of North Carolina in its ethics and conflict of interest ordinance to recuse herself from hearing the ethical issues brought forth by Ron Oxendine, which is count number 2 of Mr. Lowry's complaint. And that he says she failed, meaning Miss Moore, to withdraw from any meeting, and this is important. This is important. She failed to withdraw from any meeting or discussion if he or she becomes knowledgeable that a conflict of interest exists, as required in section 2.2.b. Specifically, Mr. Lowry says, she knew that she is the second cousin, second degree relative, he has described it, of Justice Moore, and did not withdraw from the hearing. She knew, but she failed. That's another lie. The truth is, she didn't withdraw because she knew that her familiar relationship with Justice Moore was not a violation of the ordinance. Perhaps someone should have looked up the record and brought us some official word as what first or second degree relatives means. That may would help us. I didn't do it. I just assumed that everybody knew. So he is asking you to sanction Wendy Moore because of a familiar relationship that's not prohibited by tribal law for her to have. Second cousin is not. Second cousin is not a familiar relationship of first or second degree. And even if it were, that term, remember, is used exclusively in judges and not committee members. I almost want to say this, but I'm not going to say that. If we're going to amend, and I'll go ahead and say it. I'll go ahead and say it.
And we knew you would.
I might as well say it. If we're going to allow him to amend the ordinance, sitting amongst you in this moment, sitting amongst you on the 22nd, by blood or marriage, a relative by blood or marriage to the first and the second degree, there is someone that's under the sound of my voice right now that's closer kin to me than Wendy Moore is to Everett Moore. I will wait to see if that person is going to recuse themselves and create a written record, because they're sitting on this committee right this very moment. Now, let's go on. So if we want to use that definition, if we want to amend your ordinance and allow a second cousin and consider that to be a violation of the ordinance, then my first cousin needs to get up and go and no longer participate in these discussions. I respectfully ask the ordinance committee again to dismiss this case without further delay. But if they're not, we'll quickly go on to count number 7.
Mr. Speaker.
Let's begin reading.
Hold on, Mr. Clark, if you would.
I'm sorry. Can you hear me? You referring to a second cousin against you that should recuse himself, or Wendy's that needs to recuse himself? Because the case ain't against you.
The question is this, or the issue is this. See, I became involved, and Mr. Chairman, I'm trying to respect what you said, and I appreciate you saying it.
Yes, sir.
But I understand what Miss Marshall Locklear said as well. We're trying to separate these two things, but they're so intricately connected, you can't separate them, because we wouldn't be in this one without the other one. You brought my name up, the complainant brought my name in based upon what I said in that hearing. And it's just as a tribal ethics committee person sitting on the, I'm not going to call names on this right now, a little while ago felt that because his name was brought up, that he had a right to defend it. And that is the context by which I wasn't going to say that. If that particular tribal council member hadn't felt and expressed the opinion that he had the authority, I have been placed into this whole thing. So,
Mr. Clark, if you're talking about me, I'm not kin to you.
according to the ordinance, you are. Read the ordinance.
All right, let's move forward, folks. You
Read
continue, Mr. Clark.
Relative by first or second degree. By marriage, I'm his first cousin. That's what the ordinance says.
All the skirt is going to make me.
I think. Yeah, let's continue on, Mr. Clark. Move forward, sir.
Right. Let's begin reading about 1/3 of the way on the paragraph where it says, at that very moment.
Are we on the counts, Mr. Clark? Or?
Yes, sir. I don't remember. Count 7.
Yes, sir. You can proceed. I think it's page 3 of 8. Count 7 is on page 3 of 8, somewhere there in the middle.
At that very moment, Moore should have recognized that as a sworn fact witness and the Locklear v. Oxendine, they're all connected. You can't separate them. And a sitting member of the Ethics Committee, she was in fact, take note of the word directly, using her, take note of the word authority. As a council person, to coerce, take note of the word coerce. Other members of the Ethics Committee to support Ron Oxendine's contention by the Ethics Committee, which was an attempt by Moore to coerce fellow council members to engage in political activity. Political activity, as Mr. Lowry read, is this. It's defined in the Exodus Ordinance to mean an effort to support or oppose the election or appointment of a person for political office in an election or appointment. Now let me briefly expound on that. Regarding this word authority, Wendy Moore does not occupy a position of authority over the other members of this committee. She does not occupy a position of authority over every member of this committee. She is one of 15 members. She has one voice among the 15 members, with one vote of the 15 members. She is simply a peer, simply a colleague, with no more or no less authority than the other 14 members of this committee. The office of tribal council is a political office. Holders of that office are politicians. Politicians engage in political activity. That's what this is. And not for you to engage in political activity would be unethical and a violation of your oath, and you could not represent your constituents if you weren't political. You'd just be going along with what everybody else does. Okay? That's according to Mr. Lowry. Then in exercising their duties, they are being unethical. He's saying if you engage in political activity, you're being unethical. As to the word coerce, coerce means to compel, to coerce to obedience, or to constrain. Mr. Lowry's words. So Miss Wendy Moore has used her authority, right? She has used her authority over you to compel you, constrain you. Miss Wendy Moore cannot compel, cannot make obedient, nor can she constrain any member of the council or this committee to act or not to act in a certain way. If she could, we wouldn't be here tonight. This language in this ordinance, and we have to remember, this ordinance is not written especially to the tribal council. It covers the tribal chairman, it covers employees, it covers folks who do contract services. It covers folks who volunteer, Mr. Chairman, right? This language in this ordinance, right? I lost my place. I do that when I get off over yonder somewhere and go to left field. Nor can she constrain any other member on the council or this committee to act or not to act in a certain way, if she could. This language in the ordinance, listen, this language in the ordinance is what protects subordinate employees from political pressure from actions by their supervisor. I know that because I helped write the first one. To coerce into obedience by supervisors over subordinates. That is their protection. This reference regarding to engage in political activity also is to protect subordinate employees from pressure by supervisor employees. We're right now sitting, somebody's mentioned the North Carolina Tar Heels tonight. We are right now sitting in the highest arena of engaging in political activity that the Lumbee tribe of North Carolina has. This is our Dean Dome. This is our Cameron Indoor Auditorium. It's our Major League Baseball field. It's our National Basketball Association court. It's our National Hockey League ring. It's the apex of the tribal political world takes place in this building. This is where we practice the power of persuasion that is the very nature of politics at its highest level. The bell rings when the chairman rings the bell, calls the meeting together. Then the politicians, the members, the committee members, they begin to, y'all already done something tonight when you went back there. The committee members then seek to influence by the power of persuasion, not coercion, and I'm almost done, to get everyone to see things their way, to vote their way so that they can get the results they want. Sometimes the process is ugly. Sometimes it will downright make you mad. But more often than not, most folks wouldn't believe it, but what happens at the end of the day gets things done. I did some research a few months back on another project that I was doing, and I researched the last 50 ordinances that the tribal council wrote. The last 50. 45 of those ordinances, Mr. Chairman, was passed without one dissenting vote. It gets ugly, but when we do it, it gets right. Our system of political activity works if it's done right. But according to Mr. Lowry's definition, if you ask anyone to support a candidate, to vote for someone or something, put up a sign in your yard, or promote and support a candidate, you are coercing them and violating the ethics and conflict of interest ordinance, according to his definition. Wendy Moore did nothing wrong by attesting to the residence of Ron Oxendine. He is a constituent of Wendy Moore, just as Mr. Lowry, Mr. Chairman here, spoke a little while, but looking after the interest in helping a constituent, when a constituent comes to them, he felt it his responsibility to help that person. Ron Oxendine is a constituent of Wendy Moore, lives in District Number 5, and he asked her to attest that his residence was 1837 Hezekiah Road. That's where he resides. Section 8 of the ordinance, and this is the last time I asked you to read in the ordinance. This section 8, 2 little lines at the end of it. See, the complainant doesn't want you to do this. He said when Miss Moore done it, it was unethical. This ordinance does not prohibit the activities in which individuals identified in section 1, that's y'all, normally engage on behalf of the Lumbee tribal members. It is either one of you under the sound of my voice today, if you had a constituent to say, I'm having some problems with DSS, or I need a statement that I live here, and every one of you would write it for them. If they asked you to verify something to get services at this tribal office, in housing or finance or wherever you go, there's not a one of you that would not act on behalf of your constituent. If you wouldn't, you're not serving them like you should be. If you don't believe in engaging in political activity, you cannot serve in the legislative branch of our government. Last paragraph. I could go on, but I'm going to stop. Every charge made by Mr. Lowry originated, has its genesis in the lies that we've exposed. The actual conflict of interest. Don't remember my words, remember his words. All the other allegations mean nothing. That's the real deal, he's saying. You cannot rob Wendy Moore of her opportunity to serve our government in a leadership role based upon lies or her political activity. Political activity when it's ugly, it won't work. Jamie Lowry, made by Jamie Lowry. Wendy Moore has given, this is my testimony to her. Wendy Moore has given more to this government from her participation in the writing of the original Constitution over 30 years ago when none of you weren't even thinking about Lumbee. More than 30 years. No one in our lifetime in this generation has been more dedicated to maintaining the Lumbee way of life than she. She belongs up there with the Dr. Ruth Dow Woods, the Ruth B. Locklears, and the Arlinda Locklears, and the many other powerful, dedicated women on our tribe that we benefit from having. Her dedication is certainly unmatched at this time. And don't misunderstand what I'm saying. Her dedication is certainly unmatched at this time by either one of us. And especially either one of you who are now sitting in judgment over her. That is not a slur. I'm not speaking to you in condescending terms. I promise you, I'm not. Appreciate what you're doing. It's a labor of love because you sure don't get paid enough to do it. And you have to put up with a whole bunch of junk from folks like me to get it done. Right? I'm just saying it to you. But Wendy, some of you have been engaged in tribal politics for months. She's been doing this now approaching 4 decades. Right? Leave her alone. Let her go to work. Dismiss the complaint. It's founded on lies. Of the 9 counts, like he did with the discussion stuff, it's just a repetition. It's the same thing over and over and over. And it makes it. He made 5 ethical issues over what he said took place back there in that back room that he didn't have no business doing to begin with. And he still don't know it. Unless one of y'all told him. Thank you, sir.
Yes. Ms. Moore? You have
I'd
anything
just
about
like to address the Ethics Committee. You know, all of you know me. And, you know, sometimes I'm very passionate about the way that I feel because I'm very passionate about my people. Do I go too far sometimes? Absolutely. And thank you. And there are some of us sitting here that can say the same. But nothing I have ever done, either in public or in closed session, has ever been with the intent of committing a known conflict of interest. The thing that I want you to recognize is the contentions made against me had to have my knowledge that I was doing something wrong. Has any of you ever done something wrong and didn't know you were doing anything wrong? I'm not attesting that I did anything wrong because, let me tell you something, only in Lumbee land can you tell the truth about something and then be brought up on charges for doing it. If you look at that piece of evidence that Mr. Lowry gave you, you will see that I attested only to Mr. Lowry's residence in my district. There's nowhere on there that you will say that it says I went there to support Ron Oxendine. But you know what, folks? It seems like every time we get into situations like this, all roads are leading back to Ron Oxendine and Joshua Malcolm. Let's let this buck stop here tonight. I have acted in an honorable way. I have not violated this conflict of interest ordinance. Charge me for loving my people too much? Absolutely. Guilty as charged. But you know something? What I find is the hypocrisy that a chairman can elect, can have their own CPA do the business of the LTH and the LTE no conflict of interest, no ethics charge. A person can go to a conference to represent the Lumbee people, get blasted drunk and embarrass everybody with them. No conflict of interest. We have a Supreme Court justice, a former Supreme Court justice, who sits as the president of the LTH, who acts as the legal advisor to the LTH, and is an employee, paid employee of the LTE. I do not think in my heart of hearts that Mr. Lowry is here simply of his own volition. There are too many ties that lead back to this same ugly road. And Mr. Lowry says not to be offended. Did you listen to him read what he read? Mr. Lowry was very angry. And I have never met Mr. Lowry. I have never spoke to Mr. Lowry or never done anything directly toward Mr. Lowry. Now, have I ticked off people? Absolutely I have, because I intend to be the voice and to open the doors and open the place that we call the Lumbee tribe so that the eyes of the Lumbee people can see what goes on here. The hypocrisy has to end somewhere. If I'm guilty of anything, I'm guilty of loving my people too much. Too much. But you need to understand one thing. People who live in glass houses don't need to be throwing stones. Let's move forward. Let's get beyond these things. And let's let 2022 be a year that the Lumbee people rise up again and become the people we know we can be. I thank you for your time and your efforts here, and I pray that you will deliberate according to the ordinance before you. Thank you.
Thank you. Do any council members have any questions for anyone who provided testimony this evening? Anybody have any questions? Okay, I may be going out on a limb here, and we're not going to go another hour. But any closing comments? We'll start with.
I do have a couple of questions,
Mr.
Mr. Chair, and I'll
Yes,
be
sir.
brief. To kind of help Mr. Clark out in some of his statements that he made earlier, I did not attend any closed session attended by this committee. However, what I did do was watch it on live stream, like most of the people did, and I did see where a motion was made and carried out to where a closed session was achieved. And I did watch individuals go out the door. I did not hear or have I not talked to anyone about anything that happened during that time frame. The next one is political activity is defined as activity directed toward the success or failure of a political party or person, as outlined in the ethics ordinance. Ms. Moore is not a supervisor. She is an elected official. And she thinks that I'm a little angry. I am, because I expect more out of my leaders. I expect the greatest thing that we can out of the leaders of this community. Some of the questions that we could easily add and close this entire matter out is, I would like to ask Ms. Moore a couple questions regarding some of her service that she's done. I understand she's been on quite a number of committees and she's expounded some, so I think she has a great number of successes here. But these are pertinent questions to this, some of the allegations made by Mr. Clark. Mr. Chair, if you would indulge me very briefly.
Sure.
Yes, sir. Proceed.
Ms. Moore, how long have you been a member of the Lumbee Tribal Council?
This term or previously as well?
In its entirety.
In its entirety, I served on the Lumbee Tribal Council from 2006 to 2009 initially, and then from 2019 to 2021, 2018 to 2021.
And are you acquainted with Mr. Landon Everett Moore?
Landon Everett? Yes, I am.
Do you know if he has any capacity within the judicial branch of the Lumbee tribe?
Yes, I do.
Do you have any family ties with Justice at Landon Everett Moore?
Yes, I do.
And I would like to state in this case earlier, Mr. Clark identified that she did not have any family ties earlier.
That's not what he said, Mr. Lowry.
We'll go back into the record if we need to, but he did state that you did not.
We're going to go back into the record.
What committees do you serve on?
Good gracious, almost all of them. I'm the chairman of the Constitution and Ordinance Committee. I serve on all the committees, actually.
Okay, so were you present for the committee hearing on November the 22nd, 2021, the Ethics Committee hearing related to Ron Oxendine versus Joshua Malcolm in the Lumbee Supreme Court?
Yes, I was.
During that November the 22nd, 2021 Ethics Committee hearing, did you participate in all the hearing discussions inside and in closed session?
I participated in both. I listened in here, and we went into closed session.
During those closed session matters, did any of the affidavits that Mr. Oxendine mentioned, were those brought up to your attention?
Mr. Lowry, could I remind you that closed sessions are prohibited to be discussed to anyone, and I will not for you or for any member on this committee discuss anything that was mentioned in closed session, sir. So, next question.
Right quick. Thank you, Ms. Moore.
That's what I was going to say.
Thank you, sir.
Okay, during that first hearing, could you tell any of the tribal members, all the tribal members, your constituents watching tonight, if anyone brought up any conflict of interest to you, any apparent conflict of interest with your name submitted on this affidavit?
When are you asking that?
At any time during any of those meetings, did anyone mention that there is a perceived conflict of interest or an actual conflict of interest with your name, sworn testimony, in any of the matters going on related to that evening?
Mr. Lowry, again, I will say to you, sir, unless you didn't understand me the first time, that I will refuse to answer anything that may be regarding closed session, sir.
What about an open session?
There was nothing said to me regarding anything in open session, sir.
Okay. Did you meet with Ron Oxendine at 1837 Hezekiah Road on October 20th with, and I quote, with hopes of getting his support for Teresa Locklear for Lumbee Tribal Chair?
Absolutely. Yes, I did.
Did you provide sworn testimony regarding the principal residence of Ron Oxendine?
I gave a written affidavit.
So that's sworn testimony?
That's what you say is. I didn't see it that way when I gave the affidavit. I gave it because I was attesting to the truth of his residence. And I wasn't attesting to, I want you to be tribal chairman. I was attesting to the fact that he was a constituent and he lived in my district. He lived there then, he has lived there the whole time, and he lives there now.
Okay, so did you provide the sworn testimony that you state that you had personal knowledge that Ron Oxendine was a candidate for chairman for Lumbee Tribe of North Carolina, and that he placed his primary principal residence at 1837 Hezekiah Road?
Mr. Lowry, might I state that when the time that is being discussed, October 2020, Ron Oxendine was not running for tribal chairman. I went there to ask him to support Miss Teresa Locklear. And you know what? There's nobody on this committee sitting that I haven't seen post, signs, or anything about who you're supporting. Ain't that right, Mr. Corbin?
I was going to say, I don't know if I've seen my... Let's move on. Let's move on. Amen.
Like I said before, when I gave that affidavit, Mr. Lowry, I am a layman. I have no knowledge of sworn testimonies and things of that legal nature, but I knew that when I did it, I told the truth.
So when you entered this sworn affidavit that you signed, did you know that Mr. Oxendine was going to enter it into evidence in his case of Locklear versus Oxendine? No, he was going to enter it then?
As a part of his claim that he had lived in that residence. It wasn't as a part of supporting him. In your claim, you say that my doing that said that I was support. In essence, I guess you assumed that I was supporting him, but unequivocally, I can bring Mr. Lowry up here to tell you exactly what I've told him, and I told him that I did not support anybody in this election. And if anybody on this tribal council can tell me, or this ethics committee can tell me that I did, I would beg to differ, because I've stayed out of this election totally.
And with that being said, Mr. Chair, I would remind everyone that attachment 1 that was submitted as evidence, attachment 1 was initially entered as Exhibit 12 by Ron Oxendine in the Locklear v. Oxendine case, and it is sworn testimony by Wendy Moore stating that she had personal knowledge of Ron Oxendine's principal place of residence and that she had met with Ron Oxendine in October of 2020 to garner political support for Teresa Locklear. These are all outlined in the ethics ordinance. All these allegations are outlined inside of the ethics ordinance. What I'm asking this committee to do is to take in part the ethics ordinance that we have recently passed as of 21 October and enact the sanctions that I requested. Mr. Chairman, I'll yield.
Thank you, Mr. Lowry.
Just a couple of.
All right, Mr. Clark.
Yes,
This will be finishing it up, folks. Hang in there, stay with us.
And this is, Mr. Lowry, twice in your complaint, you spoke of Miss Moore's activity as being as such that she would get private or personal gain. Or can you tell me what private gain did she hope to get by doing this? And if it's private, how do you know it?
Yes, sir, because she signed a sworn testimony to it. And I will say again, and I quote, in October of 2020, I went to the 1837 Hezekiah Road address to meet with Ron Oxendine with hopes of getting his support for Teresa Locklear for tribal chair. I declare under penalty of perjury that the foregoing is true and correct. A sworn testimony. That is her sworn testimony, sir, not mine.
But now again, I'm going to ask you, what private gain was she seeking?
Again,
I understand about the affidavit. What is she to gain?
Again,
what is of her interest, personal and private gain? What is she trying? What was she hoping to leave it in her pockets by doing that?
Mr. Chairman, I think I've already answered that question. I would like to.
Okay.
Moving forward.
Okay.
Let me go.
Okay. Now, and here's the question. Let me ask these. Were you in a closed session?
Again, Mr. Clark, I told you I was not in a closed session. However, the recorded events are still available on YouTube, and a motion was made, and you can see all the motion that was made, the second, and everyone goes out.
No, I beg your pardon, Mr. Lowry, because that's not what you said. What you said was this: both individuals participated in this hearing and actively took part in discussions or deliberations of the ethics committee when it was retired to discuss in closed session. That is not on YouTube. That is not on video. But you said they did participated in discussions back there.
She just said she
In
didn't.
closed. No,
Excuse me, gentlemen, if you would, let's make sure
Let's
we
stop.
address this committee,
Let's
that we don't
stop.
get into a back and forth with each
Let
other.
me make my own assumption here. Let me make this. Mr. Lowry, I would like to know what my relationship to Justice Moore has to do with anything regarding this case.
Ma'am, your entirety of everything in this ordinance is what I have an issue with, i.e. a personal relationship with a family member serving on the Supreme Court. Now, I'm not certain how you guys feel, but I hold my family dear. And I don't know that I would let some other individual come in and call my family bums, hypocrites, and all other kind of things. That just what doesn't fly with me. I wouldn't do it.
I understand your animus regarding Mr. Welford's unfortunate disclaimers during the last hearing, but let me be clear with you regarding Section 3, conflict of interest and public contraction for services and goods. A person reading from Section 3, number 2, and including Section A. An employee, officer, or agent involved in making and receiving awards shall be considered in conflict of interest relationship if contracting for bids and services. His or her relatives, including father, mother, son, daughter, brother, sister, uncle, aunt, nephew, niece, husband, wife, father-in-law, mother-in-law, son-in-law, daughter-in-law, brother-in-law, sister-in-law. Mr. Lowry, there is no familial ties related to my position on this ethics committee that is tied to your complaint. This has to do, sir, with public contraction for services or goods. There is nothing, and I repeat, Mr. Lowry, nothing in this conflict of interest that causes, and even if it were, there is no mention of a cousin to the second degree. I mean, folks, this is a shame. We have so much that we need to be doing for our people. There are so many things that should be taking precedent over this. And Mr. Lowry, you referred to this as foolishness. For one time tonight, I agree with you. This is about to be a foolish thing. But we need to be about the business of the people. Thank you, sir.
Thank you. To Gerald.
Mr. Speaker, I'd like to make a motion to go in closed session.
All in favor, please stand. And if you would, of course, all council members, please join us. This will be going to you folks at some point as well. Thank you.
I didn't know you was council fan, boy.
Son, yeah.
God. Mr. Chairman, I make a motion to come out of closed session.
Second. Have a motion and a second. Is there any opposition to coming out of closed session? Hearing none. Thank you very much. Thank you, folks, again, for your patience tonight and for hanging with us. It is 20 to 10, but we're going to be out of here by 15 to 10, hopefully. We shall see. But thank you again for being with us. Thank you, council members. Thank you, everybody, for serving on this ethics committee. It's never an easy task. So prepare yourself to volunteer to serve on this committee next year, possibly to serve on this committee as the chair of this committee. We shall see. But anyway, any comments, anything anybody would like to say? Do I hear a motion from the floor at this time? Mr. McNeil. Yes,
I'd
sir.
like to offer a motion.
Yes, Mr. McNeil.
Per ordinance 2010-0312-01, a person upon their knowledge of a conflict of interest shall disclose the nature of the conflict and withdraw from any meetings or discussions. Ms. Moore sent an email of communication to this committee on November 30th, 2021, acknowledging the conflict and formally recusing herself from any further deliberation. As the Oxendine complaint is still open with no decision made, we accept her recusal and sufficient, and no further action is warranted.
Mr. Speaker,
Yes, Mr.
Chairman, sorry. I second that.
Okay, we have a motion and a second. Is there any discussion from the council? Ms. Hunt?
Hold on a minute.
Bear with us, folks. We need another roll sheet. Miss Belinda?
Hold on, I got one.
I apologize. We're good. Thank you.
Corbin Eddings,
Yes.
Ricky Burnett, Sharon Hunt, yes. Gerald Goolsby,
Abstain.
Harold Smith,
Yes.
Ted Woodill,
Yes.
Carrington, Larry Chavis,
Yes.
Richard Jones,
Yes.
Reginald Oxendine, Dewey McNeil,
Yes.
Terry Hunt,
Abstain.
Shelley Strickland. Abstain goes with the
Yeah, no vote. So the motion carries. Okay, thank you.
7 on, yes.
Mr. Chairman,
Yes.
offer a motion we adjourn.
Right before well, yes, sir. Yes, sir. That's fine. We have a motion to adjourn and a second. If you would, folks, please stand with
Does
us.
she need to do a roll call? Not least.
Miss Belinda, did you need another roll call? Excellent. Mr. Goolsby, sir, if you would, could you close us in a word of prayer?
Yeah, let us all pray. Most gracious, kind Father, Lord, we just thank you, Father God, for life. This is life, Father. Father, we thank you for just